Welcome to Mentoring with the Masters. I'm Cristina Alonso, and I'm a shareholder with Carlton Fields, and I am board certified in appellate practice and have been asked to talk about initiating an appeal. And really, I'm just going to be giving a very broad overview, so I would ask that, of course, you take a look at the Florida Rules of Appellate Procedure as a first step when you're trying to figure out if you have an order that you would like to appeal. And I would also recommend Padovano on appellate procedure. And if you're familiar with Earhart on evidence, Padovano is sort of the same thing, but for appeals. And it's definitely something that's very helpful and something that I refer to. Now, in terms of the rules of procedure, one of the first rules you might want to take a look at is Rule 9.030. And that's the rule on the jurisdiction of the various courts. You can look at the Florida Supreme Court's, the District Courts of Appeal, and the Circuit Court's jurisdiction with regards to taking up your appeal. And then the next question, of course, is what's appealable? And there's three basic types of orders that are appealable. First, the final order, which is the order that most folks are familiar with. Second is a non-final order. And Rule 9.130 sets out those orders that are appealable as non-final orders. And the third are extraordinary writs. And I'm going to start out by talking about final orders. And one of the first considerations with regards to final orders is, do you have an order that is final and appealable? In other words, is it an order that has been rendered? An order is rendered when the judge signs an actual written order, and that is filed with the clerk, and it's stamped by the clerk. It's not enough that the judge, for example, gives an oral ruling. It only becomes final once it's filed with the clerk of the court. And some of the things to consider in terms of finality is, has this order determined all issues as between the parties so that there's no further judicial labor to be had in the case? Now, I would know that the court can reserve jurisdiction on collateral matters, and that would not render an order non-final. A perfect example of that would be the reservation of jurisdiction on a determination on attorney's fees or costs in the case. That would not affect the finality of the order. Other orders that might not be final are, for example, a motion that simply grants summary judgment, but does not take the next step of entering final judgment in the case as to a party. The same thing goes with an order that simply grants a motion to dismiss without then dismissing the case as to the parties. Now, there might be a partial final judgment that would constitute a final order. For example, if it's an order that determines all issues as to a party. There are co-defendants in the case, and the court enters an order of summary judgment in favor of one of those co-defendants. Well, that's a final order as to that co-defendant. And there may be a need at that point to take an appeal, not just as to the party against whom the judgment is entered, but any other party in the case that has an interest might want to also appeal that order. There might also be a final appealable order where the court enters a determination as to a particular claim in the case that is separate and severable from other pending claims. For example, you have a case where there are two breach of contract actions asserted, but there are two different contracts at issue between the parties, and the facts as to each are separate. And so when an order, for example, is entered that grants a dismissal as to one of the claims, you might be able to take an appeal as to that, because that might constitute a final order. And really, whether an order is final or not is something that's defined in the case law. There's not a rule that you can necessarily go to determine whether it's final or not. And so really I would recommend that if something is not clear to you as to whether it's appealable or not, that you do go ahead and do a little bit of research in that regard. So now you've got an order and you've determined it is appealable because it's final and it has been rendered. You have 30 days to file your notice of appeal at that point. And you would be filing that notice of appeal with the lower tribunal. A lot of times one thinks, well, I'm going to be filing my notice of appeal with the appellate court. But if you think about it, the notice of appeal is giving notice to the court that has entered the order that you're going to be appealing and the parties in the case that you're going to be taking an appeal from that order. And so you would file that notice of appeal with the trial court along with the necessary filing fee requirements. And there are filing fees that you need to go send along with your notice for the circuit court as well as for the appellate court. And in terms of what fees might apply, I would recommend that you look at the websites for the court or you call the clerk of court to make sure that you're sending the proper amount in that regard. Now, in terms of rendition of the order, there is a tolling issue that you need to consider. And that is that you might file a motion that tolls rendition of a final order. And those motions are set forth in Rule 9.020 subsection H. And when such a timely authorized motion as set forth in that rule is filed, then the order is tolled, rendition of the order is tolled until one of three things occur. One, all motions that you filed in that regard have been ruled upon. Two, you file a notice of appeal because in doing that, you've now abandoned those motions. Or three, the trial court enters an order granting a new trial because such an order would be an appealable non-final order under Rule 9.130. The appeals from non-final orders, that's governed by Rule 9.130. And you should really take a look at that rule because it really does itemize every single order that would be appealable as a non-final order. For example, some of those orders would be orders that concern venue, that grant or deny or modify an injunction, orders that determine the personal jurisdiction of the party, an order that determines immediate possession of property, entitlement to arbitration. And there are certainly others, and so you really should take a look at that rule. Now, under subsection G of Rule 9.30, it does state that those orders may be challenged on plenary appeal because they merge into the final order. So if you, for example, don't take an appeal from that order denying your motion to modify an injunction, well, you can raise that on plenary appeal from the final judgment in the case. But you do have 30 days under Rule 9.130 to take an appeal, file your notice of appeal from one of those non-final orders. And do keep in mind that with regards to those orders, there is no tolling. So if you file a motion for rehearing, that's not going to toll the time to appeal. The third kinds of orders are petitions for extraordinary writs, and those are set forth in Rule 9.100. And I would just refer you to take a look at that rule in terms of the sort of original proceedings that you can take up for review, such as petitions for cert, mandamus, prohibition, quo warranto, and habeas corpus. And so I thank you very much for joining me in this chat with regards to the rules of procedure. And of course, if you have any question, I would recommend to you that you do ask a mentor for assistance if you're taking an appeal for the first time. And there's a great program by the Florida Bar called Scope, and you can get some more information on that from the Florida Bar website, where they can refer you to an attorney with more experience in the particular area of practice to answer further questions. So thank you very much.